Good afternoon, everybody. Thank you so much for joining us here. This is the December CLE. So this is coming out of the Houston Young Lawyers Foundation. I am one of the chairs of the CLE committee that we have. So we always look for interesting topics, excellent speakers. So that is definitely what we have here today. We are grateful you're here to join us. What I wanted to do is just plug the next CLE that we have. It's going to be January 15th at noon on Zoom. We do all of these through HYLF on Zoom. So I will be the speaker at that one. So I'm going to be talking with a panel here at Thompson Co. about legal malpractice 101. So this is going to be kind of the nuts and bolts of how a legal malpractice claim and lawsuit works. So anybody who is a licensed Texas attorney or has any interest in what any of that even looks like, hopefully y'all will be able to join us. It'll be up on the HYLF website soon, so hopefully y'all can register and join us then. We look forward to seeing you then. I'm going to pass this over to Michael for introductions, and then we'll get the CLE underway. So thanks again for joining us.
Thank you, Daniel. Hello, everybody. My name is Michael Clinton. I'm a trial attorney at Zell & Associates in Houston, and I'm the immediate past chair of the Houston Young Lawyers Foundation Board of Trustees. Before I introduce our speaker, I wanted to cover a couple of our upcoming events that we have in the first quarter. We're going to have our trivia night January 15th. We're going to have our inaugural pickleball tournament January 25th. This is your friendly reminder to please meet your fellow commitments, which are due by December 31st and are a tax deduction. Your contributions to the foundation, your annual contribution, as well as anything else that you feel compelled to give, as a reminder, goes toward our ultimate goal of giving out grants to worthy nonprofits in our community. And then finally, as a reminder, we have our Law Day celebration May 1st, which I believe will be back at the Houston Club. So to introduce our speaker, while a brilliant lawyer and super knowledgeable on his topic, also one of my best friends for the last decade, it's a pleasure to get to introduce him. Robert Tsai is the founder and managing partner of the Law Office of Robert Tsai, where he handles family law, divorce, and child custody matters. Before starting his firm in February of 2022, Robert was a senior associate at a mid-sized family law firm for 6 years. And before that, Robert worked at a small insurance litigation firm for about more than a year. Robert is board certified in family law and is a fellow in the American Academy of Matrimonial Lawyers and a fellow in the International Academy of Family Lawyers. So without further ado, I'm going to turn it over to our wonderful speaker, Robert Tsai.
Thank you, Michael. I appreciate it. And thank you, Daniel, for allowing me the opportunity to speak today. Let me share my screen. For today's purposes, I wanted to give a high-level view on what family law is for non-family lawyers. I know that family law can be daunting, it's a different courts, different procedure, different family code, and more lax rules on civil procedure and evidence because of the best interest, finding that the courts can make things a little bit more lenient. So it's a little bit of more of a Wild West type practice, especially with temporary orders, which I'll get into. But I wanted to give a high-level view of some of the most prevalent issues that you might encounter in a practice, or even just talking to colleagues, or might have a tangential issue in one of your cases. I'm going to provide let me see if I can share my screen. I'm going to provide my email address as well. So that way you can always contact me if you need to. Happy to answer any questions that you might have about the case, or answer any questions about family law in general. I'm happy to always give a few minutes of my time to try and make something a little bit easier to understand, instead of y'all spinning your wheels and looking up or Googling something. So here's my email address. You're welcome to email me, text me on my office line to always. I'm usually available and can make myself available to other lawyers. I'm happy to do so. So the first thing I'm going to talk about is what is a divorce in Texas, and what generally are we looking at? I chose a divorce with kids, so we can talk about both the SAPSR suit affecting the parent-child relationships, as well as what, the property division and effectively the status change of the no marriage versus no marriage anymore. That encompasses most of the issues and encompasses a lot of the issues that as it relates to property division that we'll get into in the slides, as well as the suit affecting the parent-child relationship. I'll probably be commenting on a lot of the slides, and this is, again, a very high-level view on what we're looking at for a divorce with children. So generally, most of my cases, and almost always, people are seeking a no-fault divorce based on insupportability. This effectively means that the parties just don't want to be married together, and they don't want to live together and don't want to be together. It doesn't necessarily mean that someone is at fault. It doesn't necessarily mean that one party is to blame. There are ways to add fault grounds and seek a disproportionate division of the estate by effectively arguing that one person was at more at fault. That's a factor in effectively property division that I'll get into. But generally, most of my cases, and most of them out there, and most of the ones that courts will grant, or because they don't have to necessarily find fault if it's going to be tried to the judge, most of the time it's insupportability. Adultery and cruelty are usually the big ones that I see often in my cases. Adultery really means literally adultery. It's not going to be like an emotional affair. It's not going to be going on dates or anything like that. It literally has to be an affair. Cruelty, you can probably guess, but cruelty is probably hard to prove as well, because it has to rise to a certain level of cruelty. You can't just be usually showing evidence of being mean to each other, arguing, bickering, and having fights in front of the children, things like that. Cruelty usually has to rise to the level of a very significant type of harm to the other side, or severe mental or emotional abuse, to the point where the one case that I've had in cruelty, one of the parties was admitted into a psychiatric hospital, and one time voluntarily, one time involuntarily during a long-term marriage, based on gaslighting during the marriage, right? And also taking medication for it. Cruelty really has to be at a pretty high level for it to be found by the judge, and because certainly most cases are not, no one's going to agree to adultery or cruelty in the mediation or informal settlement process. And then as it relates to a divorce case, after you can talk about how property is divided, and then the custody issues, which I'll get into as well. So all of these factors make divorces very complicated. There are factors on how the property is going to be divided. You're not literally splitting everything 50-50. I mean, I guess you literally could do that, but most people don't, because it's impractical, time-consuming, costly. For example, retirement accounts have to be split for the most part with a qualified domestic relations order, in order to be avoid a distribution or a penalty of 10%, or being characterized as a party's income. So a qualified domestic relations order effectively splits a 401k, for example, or a pension, if later on the person accrues and gets benefits later on in their career instead of now. So I'm going to go into the steps that you would normally see in a divorce case, and then a little bit about each step, modifications, enforcements, what prenups and postnups, a little bit of a high-level view on each parts of my practice that y'all may or may not encounter. So the general steps in a divorce case. So it is a lawsuit. You have to file a petition for divorce in Harris County, which is where I mostly practice. There's 10 dedicated family law courts spread across 3 levels in Harris County. Some of the jurisdictions in the outerline counties are going to be courts of general jurisdiction, so we're all lumped together with the other civil or criminal cases. But for the most part, in Harris County, it is such a busy jurisdiction that you have to file in specific family law court. So what happens after you file? So often the judge will, most people cannot get along, or if they cannot decide, let me take that back. Most people can get along, but if you cannot, and you cannot decide where you're going to be living, paying what bills, who's having what access to what accounts, schedules with the children, possession schedule, or time and vacation, things like that, the court's going to issue temporary orders. And what are temporary orders? These are effectively, you can kind of think of it as rules of engagement during a case. How are the parties supposed to be acting and behaving, spending, where they're living, who's going to have access to the marital residence, who's going to be ordered to move out, if any, or can they cohabitate? who's going to be paying which bills, utilities, internet, daycare, babysitter, all those things are fleshed out at this time if the parties cannot agree, of course. And how often are they seeing the kids? And so that is the visitation schedule that happens almost immediately in a temporary orders hearing. These happen usually in Harris County pretty quickly because often if people are not getting along, they're going to be issues of either utilities being cut off, getting cut off access to an account or a business entity or income. I've had one of my cases that's ongoing right now. There was a business that the parties owned and operated during approximately 10-year marriage, and the husband is trying or attempted to move the company abroad to an island in the Caribbean, and we had to put a receivership in place to take control of the company and keep it here in the U.S. And so temporary orders are kind of what they sound like. If there's any imminent relief sought by a party, that's what's effectively what temporary orders are for. And the court has broad discretion on what can be ordered. Of course, if there's a prenuptial or postnuptial agreement that modifies what a court can or cannot do, then that's going to change. But for the most part, not many. If you don't have that type of agreement, then the court's going to issue temporary orders and effectively have these orders in place while the suit is pending. Now, temporary orders can be modified, supplemented, amended, added to in the middle of a case. It does not have to be, the very first month or two, what's dictating for the rest of the case. If you have to modify or supplement or ask for additional temporary orders because you may or may not be aware of all of the issues in the case until after discovery is done, for example, and you find out about an account or an entity, you send a subpoena to a business institution, and it shows that they've been transferring assets to another entity or an LLC and kind of making a shell game of sorts, then yeah, you're going to need additional temporary orders. So temporary orders can be modified and amended without much effort. It requires a hearing. And that's often why family lawyers are in court fairly often. Because of the ancillary and preliminary things before final trial setting, there can be temporary orders hearing, there can be enforcements of temporary orders, there can be compliance hearings, there can be often very long discovery battles about getting access to accounts or business documents to be able to value a business, which I'll get into as well on a high level here. But temporary orders are effectively rules of engagement, and sometimes, especially as it relates to the child issues and custody issues, it's a very quick mini trial of sorts. Because it happens so quickly, because it happens usually in the month or two of a filing, because people are not getting along, even though you're required to go to mediation before temporary orders, you might not always agree on every single temporary order or every single issue. You might have a partial mediated settlement agreement. So if there is some type of issue, it's going to be addressed very, very quickly and usually the court will limit how much time you have for temporary orders. And during that mini trial period, it can be very chaotic. Effectively, you don't have complete discovery. You do not have to disclose anything and everything exhibit. Some of the judges require it, some don't. It just depends on what the local rules require. When you're exchanging exhibits and witness lists or actual exchange of exhibits, some of them allow you to just show up and have a binder and walk through exhibits and do predicates as you go. Some don't even require that. You could there's other ways to elicit testimony that doesn't require exhibits. And very often you do not know the complete facts or situation, and you really may have 30 minutes to an hour and a half. Like, for example, I'm in court today, and I had an hour and a half limit on each side for temporary orders. And so because of the courts being so busy and having so many cases on the docket, there's 20 cases on the docket today. And that was with the presiding judge in trial. So the associate judge was hearing all the other issues. And so that's not a lot of time. Then we were left with 30 minutes and we were getting reset. And so we're not gonna be able to do a hearing on, basic issues within 30 minutes because that's pretty quick. And you might not have agreements on exhibits. You might not have agreements on other issues, or which witnesses can testify. Is there an interpreter involved? It's a lot of things can happen very quickly in temporary orders that dictate effectively what happens to the rest of the case. If you're modifying temporary orders, usually there isn't a bright line rule with judges about how you can change temporary orders in a case, but for the most part, you got to have a good reason as to what needs to be changed and why. if something is being unworkable, temporary orders are kind of like a trial period too. If you can think of it in that way as it relates to a possession schedule with the kids, because most people are not going to be accustomed to having the kids only on, every other weekend approximately, Thursdays in the school year, 30 days in the summer, split holidays, things like that. They're not really used to that, and it might not work with their work schedule. I have had pilot clients or flight attendant clients who have a modified schedule, or firefighters, for example, or even doctors. They get their schedules very as month by month, and you just don't know. And so if something is not being workable, then there's going to be a good reason to modify it. So after the temporary orders, and of course, temporary orders are really ongoing during a case if something needs to happen. But if, let's say it doesn't, and you're just sitting quietly, then for the most part, you can head into the discovery phase, which is the rest of the bulk of the case, where either you're sending written discovery, request for protection, request for written interrogatories, request for admissions. In some cases, the disclosure requests now that since now that you don't have mandatory disclosures anymore, we have to resend them again and go back to the old rules. But the discovery phase is a little bit more quiet. If I'm sending subpoenas out to banks, hospitals, medical records, and school elementary schools for school records, it's going to take a little bit of time to get those records back. It can take upwards to 30 days, range from 30 days, 90 days, sometimes even 4 or 5 months. It's important to know that lately, in the past couple of years, a lot of the financial institutions have had like a purging type policy to not hold on to statements for a period of, I think, about 7 years or so. So even when I send out subpoenas to banks, which is causing issues to prove separate property, because it's our burden of proof if you have separate property for the marriage, that is another issue that's kind of popped up recently that I'm thinking about, because those subpoenas to banks may not go all the way back in time for you to really prove with that clear and convincing evidence standard that what is separate property. So let's say depositions are done, third-party depositions are done, and we're getting ready for a final trial. Then you have to go to mediation again. Almost all the family law courts required in these Harris County and the underlying counties. It is probably it's because it works. Most of my clients like to choose their own result. If you're prepared for mediation and you can spend a day choosing your own result and having, conceding the one things that aren't as important to you and fighting on the issues that you really care about, then most of the clients and most of my cases are going to want to settle. I would probably put it at approximately 80-85% of my cases settle on some or all issues, because most, generally with discovery and disclosures and having the same set of facts or information from both sides, most lawyers can reasonably, since we're in the same judges in the same courts or against the same opposing counsels, often we can generally see have a good range of outcomes or likelihood of something happening, and have a compromise or have some type of settlement that everyone can work with. Then we're just effectively drafting the final decree or final order based on an entry date. And then if there are no agreements or there's partial issues and some need to be tried, then we're gonna have a final trial on either to the judge or the bench. I'm sorry, to the jury or the bench trial. Texas is one of the unique jurisdictions that are remaining in the U.S. where you can have a jury trial on some issues that are outlined in the family code. You can have a jury trial on who is the primary parent, as in who is the parent, which parent is going to have the children the majority of the time and establish the primary residence of the kids. You can have a jury trial on the value of property. So this comes into play when there's a business valuation for a complex business, and we have competing experts in a battle of the experts about what is the value of the business, because there's so many subjective approaches. There's a lot of nuance to those valuations, which I'll get to. And there's may not be, a joint expert that can decide it. Usually there's going to be competing experts, or there's not going to be a court-appointed one, except in, certain cases where there's a court-appointed valuation expert. You can have a jury trial on termination of parental rights. You can have a jury trial on the designation of a conservatorship and who is a joint managed conservatorship versus sole managed conservatorship. You can have an advisory opinion on attorney's fees. Most people are not going to be trying a jury trial to attorney's fees because the judge does not necessarily have to follow it. And so initial steps in mediation, I kind of already touched on this already. But what I like to do generally with my clients early on and before the first initial mediation, because almost always the temporary orders, unless there's an emergency situation where children are at risk, or a business is being dismantled or moved abroad, or some type of imminent harm, you're going to be going to mediation, right? So for the most part, when I have that mediation, I'm going to be getting my client ready for that with the last 4 or 5 years of account statements for everything, all assets and debts, even with zero balances, credit cards, IRS form to be able to get the tax transcripts from the IRS, especially for separate property, because it's so important to start, if you have to request statements from archives, the monthly statements from before the marriage, because that really the clear and convincing standard, when you come down to it, and proving separate property is really testimony plus supporting documents. So on top of testifying about it, because mere testimony generally is not enough for proving separate property, which is either property you had before the marriage, property you were gifted or inherited during the marriage, or acquired by devise or assent of some kind, right? That's generally the rules of separate property. But testimony generally is not going to be enough, so you have to have the supporting statements, and every single month you have to be able to literally trace and show to the court that each month there was no changes. You didn't, move money in and out. You didn't reinvest the money into funds. That's going to be a tough one, which is when forensic accountants get involved. When you have a fund or a financial advisor who manages the money, most people are reinvesting their dividends. Income from that separate property is going to be community property, right? So investing the dividends and then reinvesting it to acquire more income or more stocks or funds or whatever your bonds or whatever you're buying into, that is technically community property. So having a forensic accountant early on, you have to get them ready to start tracing that and literally tracing where the money is going. If children are involved, I usually get, of course, pictures of the kids, who's involved more with the kids, if there's a fight on who should be the primary parent, their health and dental insurance, medical records, a general timeline of, significant events that have occurred during the marriage. And significant, I mean, as, how often is one parent, if they're really asking for primary, I'm just going to use the shorthand primary, so that's the primary parent. How often are they really going to school conferences? How often are they really going to see the doctors, and watching out for the kids, taking care of them at the breakfast, preparing meals, doing homework, all those things, right? That takes usually about an hour or two with my clients to get ready for that first mediation, because right before the mediation, we're going to have a temporary orders hearing, because that's usually what follows. In that temporary orders hearing, I don't want to be surprised with information I don't have. I don't want to, not have information on what the other side is going to say. Generally, I want to know what the skeletons in my client's closet are, but that is important to do very early on, which effectively kind of front loads and backloads the attorney's fees in a family law case. You're looking at quite a bit of expense early on to prepare for this initial temporary orders hearing and mediation. Sometimes and often, if you have, because you're doing a high level, most important parts of a marriage, or most important parts of who's going to be primarily taking care of the kids and who was in that fight, most of the time, if there is a fight in custody or primary, generally the court is going to, order someone as the primary conservator for the kids during a temporary orders hearing, and it's going to be hard to undo that later on for final orders. So effectively having a hearing and a mini trial on the custody issue could be outcome determinative of the custody issues later on in the case. So it's really important. That's why preparation for those temporary orders hearings are so important, especially if you're time limited. You're going to have maybe 30 minutes to an hour to present an entire marriage, however long it may be, to the judge to convince the judge that your client should be the primary parent. That's pretty hard to do without, having very important facts, getting your client ready, witness coaching, and woodshedding them on what you may or may not be asking them. And so, because the judges, if you look into the judges' eyes, they are dealing with, 20, 30 cases a day. They are dealing with severe, CPS cases as well, with severe neglect or abuse or drug use, of violence often. And so, the judges are really going to be limited and really care about what is the most important part that I need to hear. What are the most important issues that I need to hear? Can it be resolved later on with another hearing? Can it be resolved in mediation? there's a real push to try and get some type of resolution and only leaving the most important issues to be tried by the judge. And so I use a lot of the times in mediation, since it's usually a half day for me, 4 hours. Sometimes I'll do 8 hours because but for the most part, those are for more complex cases. A 4-hour mediation, I talk fast, I get to the point. I'm usually going to have a quick, and I'm preparing my client before the mediation. I'm going to usually have a quick response or quick counter almost immediately because I know what my client's first offer is going to be, and I know what her deal breakers are, and I know what she wants to try if there's no agreement. So I'm usually a lot faster on that end. And when the other side is talking to the mediator in the other room, I'm not going to be I'm going to be preparing my client, practicing the outlines, direct examination, what questions I'll be asking, how to answer them, things like that if I really need to, if my client needs to. There's a fine line between that when you're actually in a hearing as well, because there's much to be said about authenticity, credibility, how you're testifying, how you're saying these things. In what we've had with Zoom, and now some of the courts will do them by hybrid, so testifying in person versus Zoom can be different. I practice with my clients on Zoom most often, and sometimes in person if it's going to be a deposition for a case that's, for example, going to a jury and is being videotaped, right? But that mediation time can be used as a way to prepare my clients for other parts of the case because I want to try and be efficient with my time. But like I said, most of the issues are going to be fairly narrow when it comes to mediation. Most of the judges want to get to the point because they're dealing with, a lot of high conflict cases all at once, and they want to just really hear the worst things. As bad as it sounds, they really do. So temporary orders, I kind of touched on this already as well. So after mediation, who's living where, who's paying what bills, all those things. You could instanter, one of the things that we have in family law court, you can instanter request drug screening if you think there is reasonable allegations or even a suspicion of drug use. The court will and has the power to hold, the parties there in the courtroom and have the drug screeners, national drug screening, come to the courthouse because they're just a few blocks away and grab hair or nail follicle or urine test for if there's alcohol or a suspicion of immediate use or recent use. Hair and nail generally approximately 9 months to a year, and I'll use those for cases that we think there have been significant drug use. To instantiate request, and I don't have to file a request for it. I don't have to file a motion for it. I can instantly request it because there's often sometimes ways to beat these tests, and you don't want to give the other side time to prepare for them. So that can happen. Mental evaluations, psychological evaluations, custody evaluations, those can all be requested at temporary orders. So there's a pretty high bar. Actually, let me go back to drug screening. So generally, what I've seen in my practice as it relates to marijuana screening and marijuana use in the case, the courts in Harris County generally, if there's a causality and a threat to the kids, yeah, that's going to be an issue and some type of inability to function. If there's a small amount of use, probably not a big deal. It's probably my safe answer. I have even had a case where I represented the non-primary parent and the opposing parties' drug marijuana use like doubled or tripled through screenings, which the court ordered during the case, and he still kept primary. And so it just kind of depends on the facts. And this is why family law is really, it can be hard to predict sometimes what a judge may or may not do. It just depends on how, it was so many things happen in a trial and so many issues as it relates to the kids. So what evidence is really going to be presented, that's really going to tilt the judge one way or the other. It's very hard, sometimes can be hard to predict. Psychological evaluations are also generally pretty hard to get. I would say the mental health privilege in Harris County is pretty high. It's a high burden. Just making allegations that someone is erratic or needs mental health, is a narcissist, is emotionally abusive. That happens a lot in cases, and in my cases, it's generally not going to be enough. You have to show some type of nexus between what that issue is, whether it's being treated or not, and why do you need to, impose and overrule an objection to mental health privilege or doctor-patient confidentiality to get these records. I would say, maybe 8 or 9 years ago, it was probably easier to get medical records. All you had to say was, or not really all you had to say, but generally, if it was a custody case, the courts and the judges, 8 or 9 years ago were more lenient and more allowed them to get the medical records from both sides. Effective also, especially if it's a divorce case and both parties are married still, right? Temporary orders, you're still going to be married. We don't have legal separation in Texas. You still have fiduciary duty. You still have a duty and care and to look out for the spouse's best interest technically, even though there's some limit to that fiduciary duty in the middle of a case. But psychological evaluations, mental health evaluations are generally pretty hard to get. Temporary restraining orders, getting an ex parte temporary restraining order, or a kick-out order or a protective order, for example, which is also filed in family law courts, even though we have our own dedicated 280th protective family law court in Harris County. You can also file protective orders in the same case of a divorce or a suit affecting the parent-child relationship if you want to have the judge that has been hearing all the same issues rule on a protective order, but they can be granted in line and while a case is pending as a separate lawsuit, kind of like an enforcement as well. So what determines the child issues? It depends, because really the best interest consideration for family law and the family code really is very broad. There is no bright line rule. There are so many factors that the court can consider, and there's so many things that are impacted that almost all the 10 judges here in 10 courts may or may not do things differently. And there's sometimes the judges might do one thing and they might do it in a different case. There's so many factors that are involved. Conservatorship, whether it's joint managed conservatorship or sole managed conservatorship, that is really just a title. Some people like to say, joint custody as a colloquial term. I don't really, when clients tell me that, I don't really know what that means. Some people think it just means like a 50-50 type of schedule between what parents might have, like a week on, week off with the kids. It's a term of art and has a different legal meaning in the family code context. Conservatorship is really, and custody as it relates to that, is what rights and duties does a parent have as to decision-making for the child. So the big ones that are usually fought about are the right to designate the primary residence of the child. So that's going to be the primary designation. That's just one right that basically makes one parent primary, one parent not. Or there might be no primary designation. Some of the courts have been moving in temporary orders here if there's a good argument for both, or there's no issues, or they might have agreed to it in a mediated settlement agreement, which is the easiest way to do it, because a mediated settlement agreement, there's case law that basically says the judge has to accept any mediated settlement agreement and they don't have any discretion to deny it. So that's a way to effectively make a bulletproof argument that may or may not be against public policy, or may not, the judge might have their own thoughts about it, but they don't have any discretion to deny it. They have to order it and they have to enter it. But the decision making as to another one is invasive medical procedures. And that's like in a non-emergency situation, because a joint managed conservator, which is generally what you generally think that a parent has a right to say discipline, right to directing the moral training, which religion child prescribes to, access to school records, access to medical records, all those things that you would think a parent can have. Well, we delineate all of those rights, and they can be modified or restricted in certain ways in a family law case, and can be on temporary orders. You can have some restrictions. So invasive medical procedures, for example, elective plastic surgery. Some judges, some courts think that shots like vaccines, anything that breaks the skin is an invasive medical procedure. Some judges don't think that. Elective, taking wisdom teeth out, that's another common one. But for the most part, most parents are going to be aligned, and most of the time they're going to be listening to the doctor on what the recommendation is, which is why you see kind of a push towards, not a push, but like a leaning towards, if the parents can't agree and they can't make a decision together because they can't co-parent well together, some of the judges will put a tiebreaker type language where if you can't agree, you're going to listen to the doctor effectively. In the recent years, we've been seeing pushback on those doctors because if you ever go to counselors or therapists that are not covered by insurance, they usually have screening questions like, are you in the middle of litigation? Do you expect to have a lawsuit? They reserve the right to withdraw or fire a patient or refuse to seek and treat a patient if there is a litigated case, and they're agreeing to not the patient and the caretaker are agreeing to not use those medical records in a litigation case, things like that for confidentiality purposes, then there's the doctors and therapists and the school educators who are for educational decisions as another big right. They're all kind of pushing back and saying they don't want to make those decisions because what's going to happen if they do in a contentious case, they're going to get brought in the case. We're going to subpoena them, and they're going to be unfortunately testifying about these issues. And so I've seen more and more physicians, doctors push back and not want to get involved and not want to be in this tiebreaker role, which you can understand, and it makes a lot of sense. Family law is heavily litigious, heavily high conflict, often for the cases that do end up going to trial. Usually there's going to be, a complaint to the medical board filed by the opposing side if there's a decision that the other parent doesn't agree to. Family lawyers are some of the most often have bar complaints filed against us. I mean, I wouldn't say my own clients do it, but it's not uncommon for the other side to file a bar complaint against me, which I kind of treat as a compliment. If I'm really going to be honest about it, because I mean, I don't represent you, but you thought I did enough of a good of a job that you filed a complaint to the bar against me for whatever you thought may or may not happen. I'm just a medium at that point. And then sole conservatorship is, as to conservatorship, the big part is all the decision-making goes to that conservator. That parent makes all decision-making decisions on psychological psychiatric treatment, which is counseling, therapy, ADHD medicine, for example, where they go to school, educational decisions, invasive medical procedures we talked about, consenting to marriage and enlistment in the armed forces is another one. Rights to services and earnings is another one that may or may not come up, or a third party conservatorship. So lately there's been recent cases that make it very difficult for grandparents or family members to seek conservatorship rights and possession and access because of often they intervene into cases, or a family member tries to have some type of possession schedule with a child or a grandparent, for example. It is very, very hard to do in Texas. There is a requirement that there is that person, whether it's a family member or otherwise, has to pass a significant impairment test to even have standing to make a suit affecting parent-child relationship type claim or intervene in a case that's already ongoing. It is a very high bar. Significant impairment is very hard to do. There has to be an imminent threat. Just because, parents have we're a conservative state with conservative legislative laws, as you'll see in the spousal maintenance that I'll talk about, but it is very, very hard to do. As a general rule, I also want to comment, because we're running out of time and I probably need to talk a little bit faster, but custody, generally, the family code and the family law courts in Texas are designed to keep parents having frequent contact and as much time as possible between the parents as much as they want. It is not designed to exclude or restrict a parent's time just because one parent says so. Otherwise, it'd be chaos, right? Even though we often litigate those types of situations. So there's a presumption that, for example, the expanded center possession order, which is approximately 47% of the time, if that parent's using all the time, is in the best interest of the child. There's a presumption of both parents are fit and should be appointed joint managed conservatorship. So all those things mean you have to prove to the court and overcome that presumption that the court should deviate from what is generally going to be the default rule. Okay, so it's going to be pretty heavy evidence and significant evidence to make that happen. Child support I wanted to comment on because it often comes up. You probably heard the 20% of net income for one child, 25% of net income, 30 for 3, 35 for 4, and so forth. There's a table in the family code that talks about it, but when you get to about 5 or 6 more, it's discretionary, but there is a cap on child support. And I think the cap's probably going to be increasing in the next couple of years or so, but approximately every 6 to 7 years, it increases and bumps up. Right now, it's $9,200 of a parent's net resources. So if they're making about $135, $140 gross, they're going to be a max payer. So what that means is for one child, they're going to be capped at no more than $9,200 of net resources per month for child support, on top of maintaining health and dental insurance, which is above that. So $1,840 for one child, $2,300 for 2, and so forth. So those caps are important to know because those are probably going to come up. Busting the cap is pretty difficult to do in Texas. Travis County, I would say in Austin, I've heard it's a little bit easier because, there's very high net worth people there. If there's special needs or a disabled child, that is a basis to bust it. But as a general rule, it's going to be pretty hard. Lifestyle alone is generally not going to be enough. I've talked about this, the conservatorship and managing possessor conservatorship and what that means as to the rights and duties. So I'm going to move forward. And then sole conservatorship, I also commented on that as well. This is effectively what type of rights and duties they have. One thing I want to comment on this one is usually there's going to be a geographic restriction on where the primary parent can live in a case. What that means is it's designed to protect the non-primary parent when there are kids involved, because if that parent can reside anywhere, technically in the world, the non-primary parent is going to have to chase that parent to be able to have time with, or he or she, I guess, to have time with their children. So it's going to be pretty difficult to do. So maybe 8 or 9 years ago, it used to be Harris and contiguous counties as the most often geographic area that was imposed by the family law courts in Harris County. Now we've started moving towards more narrow and narrower geographic restrictions, which makes sense because if it's Harris County and contiguous, I mean, from Galveston to Montgomery County, from end to end, you could be driving in Houston in peak traffic and peak rush hour, more than 2 or 3 hours potentially at a time. That is insane to be able to see your kids, and you're not gonna be able to pick up the kids after when school's out or 6 p.m. depending on when your period of time starts, or if it's a different or a modified schedule. So even Harris County, end to end in Harris County is a very large area. What I've been doing in some of my cases is making sure if they are going to live in Harris County that they understand that is still a really large area. You can do a geographic area of a zip code. You can do a geographic area of a school district if your plans are to stay in a certain school district for a while the children are in school. So when I have that conversation early on with my clients, I am usually bringing up, because I want to have a plan in place for my clients after the case is done. I tell my clients early on, if you see me again in your case, I've done something wrong, or, there's going to be some issues, right? There's some issue that you're heavily litigious or something, because you should have a plan, and it takes a lot of forethought to put into place, and it's not easy to do immediately. It takes time to think about it. You want to have a plan in place with your kids that you can live with and hope to live with, or hope to co-parent well with the other side until the kids are 18 or graduate high school, whichever comes later, which is the time that child support runs, whichever comes later. And it steps down as the kids get older if there's more than one kid. But that's my goal. I want to have that in place. I don't want to see you again if something is going to be modified, because repeat clients in the family law world are generally not a good thing, right? That means like they are heavily litigious, or there's always something to be fighting about. So the point I wanted to make about sole conservatorship before I went on that was the geographic area. There is no geographic area, or the court can not impose one for sole conservatorship. So technically that means, moving across the world is perfectly okay, which is why it's become such an issue. In some cases, geographic area and the restriction on where the parents can live is also a jury issue, for example, that can be tried to the jury. And there have been cases that are solely that issue on whether a parent can move or modify that geographic area. Discovery we talked about, so I'll kind of skip ahead on this. Discovery is generally in any litigation and civil litigation case. Those generally apply. Family law world, it's just basically either relating to the best interest finding, if it's going to be a custody type case, or some type of restrictions we're looking for. What is the discovery I'm going to be sending that is most advantageous, or that I need if another party is not complying, to get that in. Of course, the business records affidavit and filing those notices of intent to use business records, very important. But for example, the rule to file 14 days before, I've often, in a temporary orders case, because I don't have 14 days and I don't have the ability to subpoena that amount of time, if I need to get business records in that quickly, I'm usually in a bind because the subpoena is not going to become quickly enough. Some courts will allow me to do, some judges have allowed a family business records affidavit, effectively walking my client through for family business records that they've maintained in the family. That is that is definitely still going to be obviously hearsay, right? If it's a credit card, bank statement, medical records, but I have had it happen. And it's a matter of being creative with your arguments. What is it I'm using to, what am I offering it, and what purpose is that document serving? Okay, because sometimes it might not even be for hearsay purposes. I might not be using it for the purpose of what actually that statement says. Sometimes it might have independent legal significance, just that statement was said, whether it was true or not. Knowing, your rules of evidence on the fly very quickly is very important, because you can skirt around those. You can make creative arguments, not skirt, that's a bad word. You can make creative arguments as to hearsay exceptions, as to non-hearsay statements that would otherwise probably not be allowed in the civil world, because I used to do insurance litigation on the defense side, and all those things are such long cases, and a lot of preparation go into them. That doesn't happen in temporary orders, right? So you're not going to have that much time to be able to do it. So family business records I've used before for bank statements, cell phone records, credit card statements that are getting mailed to the house, because otherwise, how are you going to really, effectively get that evidence in? And most judges understand that, right? They're not going to be holding it to such a strict level of scrutiny as it relates to rules of evidence or civil procedure. It wouldn't be really fair to the parties. It wouldn't be fair to the kids if there's an imminent need. And then you can always rely on the best interests, where determine the fact, the part of the family code in the cases that say, that the best interest finding should, override, very strict interpretations of rules of discovery. Tracing, I want to touch on. I've already spoken a little bit about this, so we're going to shifting gears to property issues in a case, and effectively, how is the property going to be divided? One of the important things is tracing and getting it done very, very early, because like in temporary orders, if you might not have enough time to do it, but the court can order and impose and restrict and effectively put orders in place affecting someone's separate property, which is a very big problem if it's a lucrative business, if it is a house that the other parent is residing in. That is a big issue that you want to make sure you point out early on in the case, and make sure it's not being affected in one way. Because if it does get ordered, and the judge, and you want to try and modify it later on, the judge's going to say why. It's temporary orders. It's just during the case, but we all know that temporary orders can sometimes even last several months. It does not, family law cases, divorce cases can range from 3 months to upwards of a year. One of my oldest family law cases that I'm not on anymore is still going on because the parties are in bankruptcy, and it's been 6-7 years. It's been honestly crazy. But that didn't have separate property restrictions, but those are things to think about early on in the case, because you want to have, whether it's even ordering a certified copy of a real estate document showing the general warranty deed where a client got the inception of title of when they acquired title to the separate property home that the parties are residing in. That you need that as a certified copy. Those are easy to do and order online. But note what part, figure out early on in separate property, because getting archive statements, getting subpoenas out takes a lot of time to do. Disproportionate division, I kind of touched on that. Generally, the starting point is going to be 50-50 for when you're dividing a property between the parties. Seeking a disproportionate division, and 50-50 is value. Okay, so I want to make an important distinction on that. When I make a spreadsheet, I'm looking at all of the assets and debts that are on my Excel spreadsheet and what the fair market value is. Cash and bank accounts checking, easy. It's dollar for dollar. That's what it is going to be. Retirement and investment accounts a little bit different. We have to do a snapshot in time, because those are either invested, can be modified, can change as the market fluctuates, and some of them also have tax implications. So a 401k is not, that dollar amount is not the same as cash in an account, and is not the same as cash in a home, equity in a home. Depending on what my client's needs are, which is why I have that conversation early on in the case, what is their plan after the case is done? If I represent, for example, the non-moneyed spouse, if it's a homemaker for several years, what is their plan for the kids? What is their plan for their career? If they're going to go back to work, they need some time, a couple of years to get some skills and develop skills and be able to work and seek gainful employment. How are they going to juggle those things with kids if they haven't worked for a long time? All that depends on what mix of assets or heavy liquid, or they need to buy a house immediately. what is it they need and how much do they need, right? Generally, adultery, I do want to comment, if it's true adultery and you can prove it with objective proof, objectively verifiable proof or admission, for example, like a text message from the spouse, you're looking at approximately a 55% split versus 45, if it's the reason or the breakup of the marriage, if that caused the breakup of the marriage, right? Adultery, after the case is done, if the case has been pending for a very long time, that is going to be a little bit different, right? Because the parties are kind of separated. If both parties are doing it, that's a lot more discretionary, but for the judge to actually consider it, it's not necessarily the breakup of the marriage because they've already filed. And that's a little bit different at that point, right? Tax consequences is another reason. What have I talked about? Tax affecting what is in the 401k versus if the party is going to sell, or if one person intends to sell the residence, we need to take into account the closing costs, the realtor fees, any maintenance repairs that need to be done on it. So the equity, which is what you think the house is going to sell for, what is a willing buyer willing to pay for the willing seller of that house? Getting a real estate appraisal might change what that party needs based on tax consequences. If they need to pull out a 401k to pay a down payment, that's an account you need to tax affect. That's not something that is dollar for dollar what is actually on the asset, because that's going to be different when they actually use it, right? Spousal maintenance, our version of alimony, I want to touch on this very quickly. We don't have what's generally considered alimony, and it's called spousal maintenance in the family code. It is very, very hard to get in Texas. It is a presumption against it that you have to show you cannot meet your minimum reasonable needs. Practically, what that means is if you can probably work a minimum wage job, you're not looking at getting spousal support or spousal maintenance, excuse me. Interim spousal support is different in the middle of a case. Temporary orders, the judge can order, one spouse making money and the other one's not, was a homemaker and now needs to go re-enter the workforce. Yeah, they're going to be able to offset the income and support the other side. That wouldn't be fair, right? But spousal maintenance after the case is done, there's a heavy presumption against it. It is capped based on how many years a person has been married, as well as the lesser of 20% of gross income or $5,000 a month, whichever is lesser. So it is very, very hard to get. Almost, to give you an example of what was a settlement that I reached early on in my career, it was two doctors. One had not been practicing for 25, 30 years because she was raising the kids in a large estate. Because the larger the estate, the less likely spousal maintenance is going to be ordered, because that person is going to have sufficient income or assets from that or income from those assets to be able to meet their minimum reasonable needs. It was about $3,500 a month for the first year, $2,500 a month for the second year, $1,500 a month for the third year. Tiering down. And spousal maintenance can also be modified. So if by the person paying it, they can file a petition to modify spousal maintenance and either decrease it or eliminate it altogether with a showing of cohabitation, or remarriage, or some significant change that has happened where the court believes that it shouldn't be ordered. Business valuation, I kind of mentioned that as well. I'm going to just briefly skip over that, but that is when complex cases, my most complex cases involve valuing the business. We have business valuation experts who go into the records, 5 to 10 years of all financials for the business, interviews with the parties or the high corporate representatives to figure out, what is the fair market value, what is a willing buyer willing to pay for this part of the business. That is very complex, can take probably a month or 2 or 3, sometimes even longer. And again, it's only a snapshot as of a certain time. So knowing that business valuations become stale after 6 months is also very important, because, the person that is trying to make the valuation look less because they don't want to pay or have a offset in value to the other spouse, they're going to do what they can to, stymie growth. They're going to do what they can to not develop, all those things. And proving that and showing what growth or potential of growth, and is all very subjective. It is all based on, an art and a science to business valuation experts who are going to testify. And those can be definitely long hours of testimony, battle the expert type, hearings and trials that are very important. Prenups and postnups. Effectively in Texas, you can contract to anything before a marriage or after a marriage has started, effectively almost anything that governs, property issues. You can't make agreements on how child custody is going to be determined. That's against public policy, and you can't agree to anything illegal, or you can't agree to, inappropriate things about like sexual intercourse or things like that. Like that's going to be against public policy. So it's going to be carved out. If it's usually going to be severed from that type of agreement. But postnuptial and prenuptial agreements are another issue that a jury in Texas can decide. The validity and enforceability of a binding prenuptial and postnuptial agreement. Those can also be interesting. And often, if you have a really important case, that's determinative of the prenuptial or postnuptial agreement, that has to happen first. You're going to essentially bifurcate that case and have a jury trial on the validity of a prenuptial agreement and postnuptial agreement, determine that, and then determine, potentially another jury trial or bench trial on the custody issues and property division. It is that those cases take a very, very long time to do. Enforcement's really briefly, enforcement is a separate lawsuit. So what happens when someone is violating a court order or violating the decree after a case or during a case? You have to file a motion for enforcement, or the Attorney General's office can do, sometimes if you qualify, they can enforce child support for free, seeking contempt, and effectively representing the state of Texas, but effectively representing the side who needs it and needs the child support. But enforcement is what is the order that we're seeking to enforce? What does it say, and is there a violation? That's basically it. Very fast-tracked, quick trials, can have discovery still, but often set pretty quickly because it's very narrow issues. Modifications I want to touch on. This is the last thing as well. What happens after a decree is done and you want to change child custody orders, a schedule or conservatorship rights, flip custody, things like that. It is called a modification. The burden of proof is there must be a material substantial change in circumstances to a party, the children, or some other person affected by the order. Material substantial change test is also a pretty high bar. It's not as high as a significant impairment test, but it is a high bar. So something significant has to have happened that was also unforeseeable in your previous case, as in either the decree or as a prior modification order, to be able to succeed on a modification case. They are, I would say, they're hard to win on. They're hard to do. There's most judges don't like them being filed because it just opens up the door to more litigation. You cannot go behind the curtain or behind the prior order. So you're only looking at the relevant time period of what was the last order and then what needs to be modified and why. So, and it has to be a unforeseeable circumstance. That's also very important to note. So if the geographic area is Harris County and, for example, as a hypothetical, and the parent is trying to move to another part of Harris County and go change the school that they have the right to do, and someone files and says, well, I don't live there, and it's going to be an hour and a half for me to now see my child, that's probably going to be pretty hard to succeed on because you've already made the Harris County geographic area, and so she's not in or she or he, sorry, I keep presuming that, but he or she is not really in violation of the geographic area. They're doing things that are foreseeable by the order because that is what the geographic area is. So unfortunately, kind of tough luck. It's gonna be a hard case to win. You might just have to follow this parent around, unfortunately. So let me go. Let me add the course number again for those that are just joining, and then my email is rtsai@tsaifamilylaw.com. For anyone who has questions, I'm always happy to talk to lawyers that have family law issues, have questions about family law. Email and text to my office is the best way to get a hold of me. I'm in court all the time. I'm drinking my lunch right now, probably going to go back after this for another issue, but we're in court a lot, and which is why it's so hard for me to respond, but I'm always happy to talk about it. It doesn't take much time to answer, and it's coming from insurance defense and insurance litigation, it was such a big change in the learning curve on what the family code is and the procedures and evidence, and that hearsay really doesn't matter sometimes, or civil procedure can be really, really lenient and lax. That was eye-opening for me. So it is a very different family code system, everything. Happy to always talk and help and guide someone in the right direction if they're taking like a pro bono case and have questions about that. I don't know what else I need to do, Daniel. Oh, you're gonna take over.
Yeah, thank you. That was an incredible presentation. That was a lot of excellent information. I don't see any questions in the chat. So I guess in terms of just closing thoughts, somebody who has never done family law before, thinking about doing family law, based on all of your experience and you're board certified, what is kind of your best advice for somebody thinking about maybe taking their first family law pro bono case?
Talk to me, because I think the tough part about family law is that and I guess the most satisfying and rewarding part of it is you're affecting real people's lives. Often you have a ruling or rendition right after the hearing is done, and someone is going to lose custody or have some type of restriction. There's going to be some type of ruling that no one's going to like. It is very that's why I'm always thinking about my cases, like I feel like all the time, because if I don't do a good job at a hearing, there are severe consequences that could happen within hours. It is going to family law court is the one court where you can both have your liberty and your money taken away, right? Because you'd be in contempt of court as well as in violation of an order. The judges can do that, and then also taking money in judgment, and both those can happen very, very quickly, right? And there's so many pitfalls in family law cases that as a young lawyer, made or wish I had known, because it's very scary. Like the terminology is very different. You have to, even adjudicating the parentage in a suit affecting the parent-child relationship. If there's no marriage, you still have to find that the child has the father, if it's the alleged father or presumed father, has even rights to be able to ask what they're asking for. So, not knowing that, you could get kicked out of court almost immediately, and that has like real life consequences. They're not gonna be able to see their kid until you do the things right, right? So I would say it's a very hard thing to do, or hard family law case to break into if it's your first one without knowing anything. Because even I can point you in the right direction to some basic things that, Google's not going to be able to tell you, ChatGPT might, but it's going to be difficult, right? It's going to impact and kind of stay with you if you feel like, because all of us want to do a good job and none of us like messing up, right? So talking to me is an easy 5 to 10 minutes, lunch, happy hour, whatever it is, to point you in the right direction.
Awesome. We really appreciate you being so generous with your time and your experience and expertise. I know I learned a lot listening for the past hour. This was just incredible. And HYLF and everybody here wants to thank you for sharing your time.
Thank you. Thank you all. Thanks, Daniel. Thank you for having me.
Of course. Yeah, so thanks again. We really appreciate you being here. Everybody on the call, we appreciate you joining us. If you're watching this on YouTube down the line, join us live. It's more fun to be here live. So I guess with that, I will say, hope everybody has a great rest of the day, and we will stop recording.